3 days to file our written submissions with regards to that application of the 18th.
We are actually the ones to start because we've not filed.
So I'm not. The next step is now to give directions.
Yes.
Are you through with the?
I think that's fine.
Issues?
Yes, that's okay.
Yes.
I hear him say that he prefers to proceed with the application of the 18th on our part.
Yes.
We were cognizant of the court's time, and we thought that it might be better for the record for us to argue all the issues that have been raised together.
So the two applications we had together?
To be had together, rather than us coming before you arguing the 18th, the application of the 18th, yes. And then 2 weeks later we come back to you arguing the application of the 14th, because they're really quite tied together.
Yes.
But it would be illogical for the simple reason that if you say you are relying on this set of petition of appeal, grounds of appeal, and those grounds have not been admitted, then you cannot be able to argue for bail, referring to them as if they have been admitted. That question has to be resolved first. Because now we don't want to be dealt with in a mad or rough situation where we don't even know what are we basing our applications on. So it is also occupational hazard that if it requires us to come twice, we shall need to come twice because of the logic of the situation. It is not possible to say that you are arguing them together and we've not admitted those grounds.
Can you seek leave to appeal and at the same time seek leave, stay execution?
Leave to appeal. Melody, that's why we are saying.
No, I just wanted us to understand whether we can handle the two together.
We cannot handle them together because the applications for bail is premised on grounds of appeal that ought to be admitted. Because our right to refer to them is based on admission.
But you have sought leave for them to be deemed as filed.
Yes, but we have not been given leave. It's just like even an amendment in civil procedure. If you want to seek an injunction and there is opposition to an amended plaint where the injunction is sought, you'll have to deal with that issue first of the amendment. So it's actually them who are complicating a small issue.
No, I thought we were trying to save time, but...
No, that saving time throws us into a serious matter of logic, which I don't think we can just go into.
I agree.
Yes.
So then we need your application, which is the March.
Yes.
But Your Honor, my lady, perhaps in the...
Yes,
Yes, my lady, perhaps in the interest of saving the time that the respondents are conceding to, how about if the court considered on its own motion, but all what we are here for is for seeking of leave? Why should we consume court's precious time when the court itself can swim more to make a determination whether a right to amend can be denied? So that, Your Ladyship, then we are saying that we'll be then in sync with the respondents, that we are all saving time, because we shall only be urging the question of leave. And the court can, on its own motion, exercise that discretion.
But your application for leave is opposed. You have to be an... Yes. You see, this is not an issue I can exercise my discretion. Because the application for leave is opposed. We have grounds of accusation and it's a preliminary objection.
I agree with you, but my lady, if I recall when the last time you were here before you, what was in contention was the manner in which our amendment was worded.
Yeah.
So the contention then that day was, should it be a supplementary petition of appeal or should it be an amended?
Yeah.
That's what the only bone of contention. And therefore, if you have brought before you a document that is correctly worded, then I think then perhaps logically it would mean that the same would not be contentious.
You see, as long as there are grounds of opposition, what does that mean? The application is opposed.
We'll take your ground.
Unless it is by consent, then I have to hear all the parties and I have to make a ruling. Because this is leave to amend, isn't it? And it is not automatic.
We'll take your elections.
It is not automatic, and I believe that is why it is opposed. And therefore, we have to hear the application.
Much obliged.
Yes. So therefore, I've marked your prayer 2 of the application dated 14th of March 2025 as abandoned.
Yes.
So now I'm giving directions, and you have asked the court we can proceed and first hear the application dated 18th of March.
March, yes.
It is not an application where parties need to highlight.
We believe we need to highlight. You let us highlight. It will not take.
I thought in the interest of saving time, we would do better by not highlighting.
My lady, they are always.
And I've always said,
Yes.
this court doesn't believe in highlighting of submissions in all the matters. Okay? Unless you insist, I don't think you need to come and highlight these submissions.
Then you can give us date for ruling.
Yes. As long as you file your submissions on time.
We will.
Maybe we can have a mention to confirm parties have filed, so that I give a
We
date
can
for
do it on
ruling.
here.
Yeah, just to be sure. Because the problem I get is
Yes.
that when I give a date for ruling, parties don't file submissions on time. When I've done my ruling,
Yes.
a day before, that is the time a party is filing submission.
In this one, they really want to come out.
Sorry?
They really want to come out,
It
so
is
I
easier
have to
said-
comply.
it is easier
No,
said
no, we shall have
than
to
done.
comply.
I'm sure by that.
Unless I give a very clear order. But if I don't receive the submissions on that list, whether you file them or not, I will not proceed.
My lady, I suggest that you reserve a ruling date. Even if we are mentioning the matter, in that case, we can even mention it partially without having to appear in court on the 5th.
Then why do I reserve a ruling date if we have to mention? I thought I was just reserving a ruling date.
Just give us a
Just give
ruling.
a ruling date.
So that we
It's
don't
okay.
have to
That's
again
okay.
mention the matter.
That's okay.
That's okay.
Yes, but on condition, and I'm putting it on record.
Yes.
Yes, because I hate going back to the drawing board to do a ruling. Because submissions have been filed when I've already done the
We shall file this on Tuesday.
yes, so please comply with the timeline so that we save time. Give us a date for ruling. And if there are any list of authorities, please file them together with the submissions.
Yes, we will.
Yes, I'm being reminded that the recess starts, the short recess starts from 9th of April. So we have to mention it before then. Again, ruling, I have to deliver after the recess. Yes, you deliver the ruling on 23rd of April at 9 a.m.
That's pledged. It was not possible to come in.
Sorry?
It was not possible to come in to Italia.
We are resuming on 22nd.
Oh,
I've
we are
given you the
resuming on
first date after
22nd.
the recess.
Thank you. I didn't know that.
Yes.
It's okay.
Yes. So on that date at 9,
It will be a virtual or we come to court?
you can deliver it virtually.
Yeah, if you direct that.
Yes.
Although we were assuming,
Yes.
because of the second application, after you deliver your ruling, it might help us if we directions on the other application could be given immediately after delivery. Because there are two applications.
You can still give them virtually,
Okay,
isn't it?
that's okay.
Unless you insist.
That's okay. So that's okay.
Yes, because it's just a matter of delivering the ruling and
Yes.
giving directions on the other
On
application.
that application.
And the respondents have filed their responses. So it's just a matter of giving directions and filing of submission.
Okay.
So if there isn't much,
Thank you.
the directions to give for the other application. Yeah, so we can mention it virtually.
Okay. Thank you.
Yes, we are still on for
We can
ourselves.
leave.
Yeah, we have another
Okay.
matter. Yes.
Much obliged.